All right, this is the start of Part 1B of Federalism. We're going to take a look at the historical views on federalism and just introduce you to some ideas about fiscal federalism. All right, remember that the founders differed on the question of how strong the national government should be. If you recall, the supporters of the New Jersey Plan wanted strong state governments. Alexander Hamilton wanted all the power given to a national government, while supporters of Madison's Virginia Plan fell somewhere in between. And so the Constitution was the result of a compromise between these different groups. So the states retained some powers, remember the 10th Amendment, while the national government were granted others in an effort to balance the powers between these two levels of government. And we'd already discussed what a unitary system would be like, strong, very strong federal government, and a confederation system, which would have been very weak federal government, and defined that the federal system was somewhere in between. So we were able to put these on a continuum, if you will, from confederal, having very weak national government, to unitary, very strong national government. There's two more points that I want to add to this continuum. And in the early days of our country, there was two predominant views of just how strong the federal government was going to be. So you had a state-centered or states' rights view of federalism, and this is point A on the continuum. And so those people who adhered to the state-centered view of federalism took a very narrow view of the powers of the national government and argued that states should be able to overrule the national laws. And so this is where Jefferson and Madison would place themselves in terms of how they wanted the states' power vis-a-vis the federal government to be. So this is where we put the A between confederal and federal forms of government. And this state-centered federalism was actually the type of federalism that was in play and was dominant from the beginning of the Union till about the Civil War period. So from the about Jeffersonian time and the time when we had the first the Constitution was actually ratified till about the Civil War, state-centered federalism was probably the norm. And this becomes Jefferson's viewpoint, and then when we talk about political parties, the early political party would be the Jeffersonian Republicans. As you recall, there was already disagreement about the relationship between the nation and states during the writing, adoption, and ratification of the Constitution. And these disagreements developed further with the advent of political parties. And so again, this Jeffersonian Republicans emphasized state and local power and a more stricter interpretation of the Constitution, where the Federalists like Alexander Hamilton and John Marshall argued for a more broad interpretation of the Constitution that allowed for a strong national government possessing those implied powers that we talked about, as well as the enumerated powers found in Article 1, Section 8. All right, so nation-centered federalism then, denoted by the letter B on our spectrum, would be those who wanted more power to the federal government. And again, you have Alexander Hamilton and John Marshall at this side, and this would evolve into the Federalist Party. Okay? So from the very beginning, we have our two different parties and our two-party system very much like we have today, where state-centered federalists would be modern-day Republicans and nation-centered federalists would be modern-day Democrats. And so you can see this division from the very beginning. Of course, we had several issues that intensified these particular disagreements over how much power the national government should have. And of course, those was going to be sectionalism and slavery. So if we think about the time from the Founding Fathers to the Civil War, we have this state-centered federalism, which was dominant. And the issue of sectionalism really intensified the disagreement about the power of the national government and the relationship of the nation to the states. So for example, the northern and southern states were especially adamant about the question of tariffs or taxes, which the North favored and the South opposed. Well, the compromise, like those made during the Constitutional Convention, might have been forged if it were not for the reemergence of an issue about which there could be no accommodation, slavery. So this idea of sectionalism and whether or not southern states could buy federal laws became a big issue. Along the same lines, the issue of slavery would come about, and in particular the Dred Scott case. A majority of the founding fathers and framers of the Constitution might have assumed that slavery would eventually disappear on its own, since they had provided an opportunity for Congress to act after 1808 to abolish it. And one of the most important and controversial Supreme Court decisions in American history was the Dred Scott
case of 1857. And so here's a little bit of the background of the Dred Scott case that you may already be familiar with. Mr. Scott was a slave and had been taken to the free state of Illinois. And then he was taken to the free Wisconsin territory, and then later back to Missouri, which was a slave state. So here you have a gentleman who was a slave but had been taken to a free state and then a free territory, and then he traveled back to Missouri, a slave state. In 1846, note the date, in 1846, Scott sued the man who had held him in servitude on the grounds that he had achieved his freedom by living in a free territory. When the Missouri Supreme Court ruled against him, Scott sued the Federal Circuit Court, or he sued in the Federal Circuit Court in Missouri. When that court also ruled against him, Scott's attorney appealed the case to the U.S. Supreme Court. So his initial case started in 1846, but it wasn't until 1857, 11 years later, that the Supreme Court handed down its decision. The Chief Justice at the time wrote the court's opinion and reached two conclusions. And they were very explosive in their significance, so be sure and write these two down. The first decision or conclusion he made was that whether slave or free, that blacks could not be citizens of the United States. Individual states might grant them state citizenship, but they could not enjoy the rights and protections of national citizenship under the Constitution. The Chief Justice reached this conclusion on the grounds that blacks were not recognized as U.S. citizens when the Constitution was ratified. So that's the first thing, that he argued in his opinion, and this was the opinion of the court, that blacks could not be citizens of the U.S. Secondly, the argument from the court was that the federal government did not have the right to exclude slavery from the territories. Enslaved Africans, he argued, were property, and property rights were protected under the Due Process Clause of the Fifth Amendment. The right to own slaves, in other words, was protected by the Constitution. A slaveholder, he argued, therefore, had the right to take slaves into the territories. The court hoped that by invoking the authority and prestige of the Supreme Court in so definitive of a ruling, he could peacefully resolve the conflict over slavery and help avoid a civil war. His opinion, however, had exactly the opposite effect. Many believed that the Dred Scott decision was one of the principal causes leading up to the Civil War. All right, so you can see that in this time frame, the states and even the federal courts ruled in favor of state-centered federalism. That is, they ruled in favor of giving states more authority than the national government. There was, however, a few cases where national-centered federalism dominated. And again, national-centered federalism took the argument that the necessary and proper clause and the principle of national supremacy meant that the federal government had powers beyond that were listed in the Constitution. And a couple of these Supreme Court cases bear this out. So there was a case called McCulloch versus Maryland in 1819, which was a dispute over the constitutionality of the national bank that was created in the early years of the Republic. The state of Maryland maintained that the banks were unconstitutional because the Constitution itself made no mention of the right to create banks. The U.S., on the other hand, argued that the right to create banks was implied. Remember, the Article 1, Section 8, Clause 18, the necessary and proper clause, implied. The U.S. argued that the right to create banks was implied by the constitutional authority of the government to collect taxes, borrow money, and regulate commerce. The government's ability to collect taxes, borrow money, and regulate commerce are expressed. They're written in the Constitution. Article 1, Section 8, Clause 18
the necessary and proper clause, instructs Congress has the right to enact those laws which are expressly written down in the Constitution. So the court favored the national government in this particular case. The federal government has implied powers, giving more power to the federal government. Basically, the McCulloch versus Maryland case reaffirms the implied powers of Congress. So that's why it's an important case, and it shows that the federal government has more power because of its necessary and proper clause. All right, a second case is something called Gibbons v. Ogden in 1824. And the background, just briefly, is that New York had let one steamboat company have a monopoly on the travel between New York and New Jersey. Just like today, there's lots of people who travel between New Jersey and New York on the ferry system. The national government maintained that only it had control of interstate commerce. After all, this New York Steamboat Company was going between states, and then New York was outside of its rights in establishing this monopoly. In other words, New York does not have the right to establish a monopoly, since that right is with federal government. The federal government has the right to regulate interstate commerce. Once again, the national government was winning this balance between who had more power, the state or the national government. So in cases of interstate commerce, the court ruled that the national power was greater than that of the state power. All right, as we approach the Civil War, however, we start to see the balance moving more and more toward nation-centered federalism. So the Civil War is an important event. Okay? And of course, the question arose, do states have the right to pull out of the Union? The South maintained that state power should override that of the federal government, and that they had the right to dissolve the Union at any time. The North took the position that the national government took precedence over the states, and that no state had the right to dissolve the Union. Of course, the issue of slavery, commerce, there were a lot of particular issues that surround the bigger issue of who has more power, the state or the federal government. Well, after the Civil War in the late 1860s, you have what becomes known as dual federalism. And this lasts between the end of the Civil War up until almost World War I in 1913. Dual federalism lasts between 1865 and 1913. The First World War is really a little bit later, a few years later. But under this doctrine, the two major levels of government are separate, and they tended to act on their own, free from interference from the other level. So dual federalism was a predominant view during this time period. And one political scientist who's an expert on federalism made the argument, or made an analogy to a layer cake. He said dual federalism was like a layer cake in which the two layers were kept neatly separated by a thin layer of icing. In the 1930s, with the Depression, this view of dual federalism, of course, fades away, and it's replaced by what is called cooperative federalism. And continuing the cake analogy, cooperative federalism is like a marble cake, in which the federal government and state governments are swirled together. In any slice of governmental activity, from criminal justice to health policy, you're apt to find the two levels of government actively mixed together. So cooperative federalism is a system in which areas of government or different levels of government share responsibility within the same policy issues. And one good example is because of the 16th Amendment, which allowed income taxes. So you have a new flood of money that the federal government now had control of. Before the 16th Amendment, even if the federal government wanted to enact certain policies, they didn't have the money to pay for it, whereas states did. So the federal government had a hard time convincing states to act without the money associated with that. So you have dual federalism on one hand and cooperative federalism in the other. So dual federalism, where states and the federal government are acting independently, where the federal government isn't interfering in the states' laws and procedures, occurs from the end of the Civil War up until about the 1910s, 1920s. After the Great Depression, you have much more of what is called cooperative federalism. So as we move further and further into the 20th century, dual federalism is no longer working. So why did cooperative federalism emerge? There were several problems that were very difficult for states to solve on their own. And if it wasn't for the federal government, we would still be experiencing some of these issues. And the first is to answer the question of why dual federalism was no longer viable. The first is the issue of civil rights. One of the main issues that the Civil War was fought over was federalism, as I mentioned, or the idea that state powers can override the federal government. Well, after the Civil War, the 13th, 14th, and 15th Amendments were adopted. Just very briefly, the 13th Amendment eliminated slavery. The 14th Amendment denied states the right to make laws unsatisfactory to the national government. It's also the 15th Amendment, which denied states' rights to disallow people's right to vote based on race, color, or previous enslavement. So together these are referred to as the Civil War Amendments. So these amendments, again, eliminated slavery, gave due process and equal protection to African Americans. It also said states could not deny people the right to vote based on race, color, or previous enslavement. However, this doesn't mean that right after the Civil War, all states, including southern states, all of a sudden let everyone vote. The Supreme Court did not begin to protect these rights until well after World War I. Well, why not? Because federalism was still operating under a state-centered form of federalism, or dual federalism. So the transition from dual federalism to cooperative federalism was a slow one. The 14th Amendment says that no state shall make or enforce any laws that shall abridge the privileges or immunities of citizens of the United States. With the 14th Amendment, Congress begins to incorporate the Bill of Rights to the states. Before this time period, the Supreme Court and the federal courts basically looked at the Bill of Rights and said this applies to federal government. It doesn't apply to state governments. It's after the 14th Amendment that the Supreme Court and the federal courts start looking at how the Bill of Rights are going to be applied to state government and local government. Let me just give you one example of this transition from dual federalism to cooperative federalism dealing with civil rights. So in 1896, the Plessy v. Ferguson case, a very famous case, the Supreme Court upheld a law, a state law, requiring segregation of the races in public transportation. This is the court case that sets the precedent for separate but equal facilities for blacks in America. This is also the time of dual federalism, where the state government and federal governments are independent of one another, the layer cake analogy. However, by the 20th century, the Supreme Court began to assert national authority over the issue of civil rights. So anytime you think of the Plessy v. Ferguson case in 1896, you should also think of the Brown versus the Board of Education case in 1954. Here the Supreme Court ruled that the segregation of races in public schools violates the Equal Protection Clause of the 14th Amendment, and so the court ordered that desegregation should proceed with all deliberate speed. So the Plessy v. Ferguson case is overturned by the Brown versus Board of Education case. This overruled the previous separate but equal doctrine that had been in effect. So the moral of the story is that if it left to the states, the Civil War amendments would have had minimal enforcement and no uniformity. Remember how I said last time that one of the disadvantages of federalism was that states were more likely to disrespect individual rights, and we see that throughout the end of the 19th century with Jim Crow laws and rules such as separate but equal. After the Civil War, constitutional amendments were passed that prohibited the states from taking away the civil rights and voting rights of its citizens. This approach was not successful as states passed laws designed to maintain white superiority in the South while not allowing blacks to vote. In the spirit of dual federalism of the time, the federal government did nothing, in effect giving the states the authority to deal with racial issues as they saw fit. Ultimately, however, as we moved toward the middle of the 20th century and the advent of cooperative federalism, the federal involvement at the state level in the 50s and 60s became necessary in order to make civil rights for blacks a reality. All right. Another example of why dual federalism was no longer viable in the 20th century was that of economic regulation. In the 19th century and the early part of the 20th century, the Supreme Court defended the idea that the national government had no right to regulate the economy, and this, the court said, was reserved to the states under the Constitution. But as we move into the 20th century, you have more and more citizens moving into the cities, and we have a more urbanized society, and a number of new problems arose. So issues such as unsafe factory working conditions, where you had poor young people, young immigrants were hired by manufacturing interests to work 14, 16 hours a day in conditions that were unsafe. And so this deprived them of a chance at education, being doomed to a life of poverty. And so responding to some public outcry against child labor, Congress called attention to its power to regulate interstate commerce. Remember Gibbons v. Ogden. And they passed a law which would not allow items manufactured by child workers to be transported across state lines. However, because we're still in the era of dual federalism in 1918, the Supreme Court claimed that the Interstate Commerce Clause was being used to cover up an invasion of the state's authority to regulate the welfare of its own citizens. So the child labor law was declared unconstitutional. You have a case where the states made an argument that the courts agreed on, that it's up to the states to regulate the welfare of its citizens, not the federal government. Of course, we know that child labor is now is not practiced today. We have that protected, and it was during the Great Depression that the Supreme Court went through what was pretty much a complete turnaround. So by the end of the Great Depression, the federal government's power to regulate commerce was being upheld by the courts. So you see from the time of dual federalism, the courts ruled in favor of the states, and by the end of the Great Depression, the 30s and 40s, the Supreme Court was ruling in favor of the national government. Without this turnaround, we might still have child labor, and none of the regulations of the federal government that serve to maintain the workplace in terms of safety and consumer product safety would not have been passed. So you can see where the federal courts were starting to intervene on the part of the federal government's right to regulate certain issues dealing with civil rights and the economy. So that was a long way to tell you the difference between dual federalism and cooperative federalism. So just as a reminder, under dual federalism, you have a separation of what the national government and the state government were doing in terms of policies. So under the era of dual federalism, even though the federal government might make statements and laws dealing with equality, the states were engaged in practices such as Jim Crow laws. In the era of cooperative federalism, there's going to be cooperation on policies where the national government and the states agreed to certain legislation and principles that guided behavior of both the national and state governments. Well, as we move into the Vietnam War era and the 70s and 80s, we start to move into an era called devolution. This is a new form of federalism. And devolution refers to the idea of passing down authority from the national government to the state government, and this could be thought of as a modern-day state-centered federalism. So again, devolution is defined as passing down authority from the national government to the state government. So if you look at the trend, we went from, at the very founding, a very state-centered form of federalism, where you had dual federalism. In the middle of the 20th century, you had cooperative federalism, where the national government had more power and there was shared governance. And now we move to a period where the federal government is passing back authority to the state and local governments. Well, why is this occurring? Well, of course, it's always about money. Budgetary problems in the 1980s included large federal deficits requiring states to forge their own way. And many believe that the federal government caused more problems than they solved. And then by the time you get into the 1990s, you have the political developments, specifically the Republican Revolution. So here's a gentleman you should recognize. Newt Gingrich, of course, is running for the Republican nominee for the president this time around. But he was Speaker of the House in the 1990s and was one of the leaders of what was called the Republican Revolution in the 1990s. And one of the major goals was to return power to the local and state level. And so this was due to the fact that the federal government was instituting what are called unfunded mandates, where the federal programs required action by states or localities but provide no funding to pay for that program. So the federal government, in an unfunded mandate, would tell the state, you have to provide X for your citizens, but they didn't give the state any money to carry out that policy. The Republican Revolution wanted to reduce the number of unfunded mandates, and they ushered in things like the 1996 Welfare Reform Act. In reality, however, this rollback of nation-centered federalism has been quite minimal. We've actually seen an increase in federal control over many issues. No Child Left Behind, for example, the creation of Homeland Security, the Patriot Act. So even though there was this move toward devolution, we still see a lot of federal oversight in many of the social and economic issues that we see today. In terms of what the courts have been doing, in recent years the Supreme Court has acted to restrict the federal government's power, favoring state power. So again, even the courts are rolling back some power. And there are several court cases that exemplify this. One was U.S. versus Lopez in 1995, where the court struck down a federal law prohibiting the possession of guns within 1,000 feet of a school. Congress had passed this law based on the Commerce Clause, but the court ruled that the ban had nothing to do with commerce or any sort of economic activity. This doesn't mean that the courts are saying we shouldn't have these types of laws, just the rationale was wrong. In other cases, the court limited federal authority to in government's decisions regarding employment based upon age and disabilities. Okay, so the courts is giving the states much more authority over hiring practice. However, in other cases, the Supreme Court has upheld federal laws, particularly when they pertain to private companies and firms. All right, there's a couple of examples about this new federalism that I thought I'd highlight. In the 1970s, this is a picture from 1973, where gas was in a shortage because of the acts of OPEC. And so you had a debate between the national government and the federal government on what to do about shortages of gas. And this is where the national government instituted a speed limit. So there was a time when the national speed limit was 55 miles per hour on the freeways. When I was a little girl, this is what we used to do on a Saturday, go get gas. It would take hours for you to get in line to get gas. And so we don't really see this type of activity today. But the whole roads and who pays for the roads has come up more recently when it came to legalizing the drinking age or increasing the drinking age. We get money from the federal government to maintain the highways. So in order to address the issue of alcohol consumption of minors, the federal government wanted to end legalized drinking for those under the age of 21. So in 1984, the federal government passed a law or wanted to deal with this particular issue. Only 29 states allowed people under 21 to purchase and consume alcohol at that time. But Congress realized they could not pass a national law prohibiting drinking under the age of 21 because they didn't have the right to deal with this issue at a state level. With the exception of prohibition, regulating liquor has always been the responsibility of the state. So in order to get around this, Congress tied the drinking age to the highway bill. So under the provisions, states would lose 5% of their federal highway funds in 1986, 10% in 1987 if they allowed alcohol consumption under the age of 21. So if you think of a state like Louisiana and the city of New Orleans, whose tourism trade relies heavily upon Bourbon Street, the idea of lowering your drinking age to 21 was going to have a big economic impact on the state. Supporters of this action said that the national government's responsibility to maintain order justified the intervention. Groups like Mothers Against Drunk Driving had fought hard to increase public awareness. The National Transportation Safety Board estimated that 1,250 lives could be saved each year by raising the drinking age. Opponents, of course, argued that it constituted age discrimination and infringed upon states' rights. So here again we have an issue between the federal government and the state government. They claimed it was an unwarranted extension of national power that limited the freedom of the states and their citizens. All right. Several states took the matter to the courts, hoping to have the provision declared unconstitutional. In June 1987, in the case of South Dakota versus Dole, the Supreme Court ruled that direct congressional control of the drinking age in states would be unconstitutional. However, there was no constitutional barrier to indirect congressional action. So they argued that the federal government had the right to deal with interstate commerce and issues with funding transportation, and this was an indirect control, and there was nothing in the Constitution that prohibited that. Right, so that's just one example of the fight for federal money and how the states and the federal government disagree and who has more power. This idea of new federalism was an attempt by the Nixon and the Reagan administration to devolve many policies back to the states. And most of these policies dealt with what we're going to call fiscal federalism. And so here's where we're going to talk about block grants, general revenue sharing, and how federal spending and interference from the federal government impacts the state. So this is going to be the next lecture that we talk about fiscal federalism in part 2. So here's where we'll end today, and we'll pick up next time on fiscal federalism.